Our ninth important leading case under love contract is Madhav Chandra versus Raj Kumar Das, and in the very case is based on agreements in restraint of trade. In this case, the parties carried on business as braziers in the same quarter of Calcutta. The defendants suffered loss from the plaintiff's competition and agreed that if the plaintiff closed his business in that quarter, they would pay him all the advances he had made to his workmen. The plaintiff complied, but the defendants failed to pay. The plaintiff sued to recover the amount of the advances, but the restriction, though confined to a particular quarter, was held to be void as Chief Justice Koch observed that the words restraint from exercising a lawful profession, trade, or business do not mean an absolute restriction and are intended to apply to a partial restriction and restriction limited to some place. And in the 10th important leading case, that is Charlesworth versus MacDonald, and in this case, the defendant agreed to serve the plaintiff, a physician and surgeon practicing at Zanzibar as an assistant for 3 years. The latter, which stated the terms which the plaintiff offered and the defendant accepted, contained the words the ordinary clause regarding practicing must be drawn up. No formal agreement was drawn up, and at the end of a year, the defendant ceased to act as the plaintiff's assistant and began to practice in Zanzibar as his own account. It was held that the plaintiff was entitled to an injunction restraining the defendant from practicing in Zanzibar on his own account during the period of the agreement. Thus, the very principle is an agreement of service by which an employee binds himself during the term of his agreement not to compete his employer directly or indirectly is not in restraint of trade. Such an agreement may be enforced by injunction where it contains a negative clause, express or implied, providing that the employee should not carry on business on his own account during the very term of his agreement. And the next leading case is Fraser and Company versus the Bombay Ice Manufacturing Company. And the very principle of this case is a stipulation restraining the parties to a combination agreement from selling ice manufactured by them at a rate lower than the rate fixed in the agreement was not void under section 27 of the Act. A stipulation not to Kin cotton or to sell ice for less than a fixed rate does not restrain any party to the contract from gaining cotton or from selling ice. In other words, none of the parties is restrained from exercising his business of gaining cotton or selling ice. What it does provide for is that in the exercise of the business, certain terms shall be observed, and in the next important leading case, that is LMI versus Positive Government Security Life Insurance Company, the very defendant company issued a policy for a term of 10 years for rupees 25,000 on the life of Mehboob Bibi, the wife of a clerk in the employment of the plaintiff's husband. About a week later, Mehboob Bibi assigned the policy to the plaintiff. Mehboob Bibi died in a month later, and the plaintiff, as assignee of the policy, sued to recover rupees 25,000 from the defendants. It was held on the evidence that the policy was not effected by Mehboob Bibi for her own use and benefit, and that it was void as a wagering transaction. The insurer, having no interest in the life of Mehboob Bibi, in India, an insurance for a term of years on the life of a person in whom the insurer had no interest was void under Section 30. And our next important leading case is Westshire versus De La Tour 1853. Here, De La Tour agreed to employ Westshire as an attendant to go in advance of touring parties and to make necessary arrangements for their stay, etc. The agreement was made on 12th April, but the appointment was to commence from 1st June. On 11th May, De La Tour wrote a letter to Westshire stating his inability to employ him. Westshire immediately brought a suit for damages, but he was asked to stay till 1st June, the time fixed for his appointment, and it was held that it was a case of anticipatory breach of contract, and Westshire was entitled to bring a suit for damages immediately, and it was not necessary for him to wait till 1st June, the very day of performance of the contract. And now we'll go to another important leading case, and that is Henderson versus Stephen Chan. So there has been a question arising whether the proposal of special terms has been effectually communicated. This arises where a contract for the convenience of a passenger or for the carriage or custody of goods for reward is made by the delivery to the passengers or owner of a ticket containing or referring to special conditions limiting the undertaker's liability, and nothing more is done to call attention to those conditions. English authorities have established that it is a question of fact whether the person taking the ticket had or with ordinary intelligence would have notice of the conditions or at any rate that the other party was minded to contract only on special conditions to be ascertained from the ticket. In either of these cases, his acceptance of the document with the protest amount to a tacit acceptance of the conditions, assuming them to relate to the matter of the contract and to be a more or less usual kind, but he is not liable if the ticket is so printed or delivered to him in such a state as not to give reasonable notice on the face of it that it does avoid some special conditions. This is the principle of this case where an endorsement on a steamboat ticket was not referred to on its face. So, in our next important leading case, that is relating to Krell versus Henry. So, having regard to the unqualified language of the act, it seems useless to enter at more length on the distinctions observed in English law. The illustrations do not indeed appear to go beyond English authority, but this cannot detract from the generality of the enacting words. So, the very fact of this case was H agreed to have the use of case room in London on the days of 26 and 27 June 1902 for the purpose of seeing the intended coronation procession. By reason of king's illness, no procession took place on either of those days. It was held that K could not recover the balance of the agreed rent as the taking place of the procession was regarded by both contracting party as the foundation of the contract. And now we'll go to another important leading case, and that is the 16th number of case, which is Sheikh Ismail versus Amir Bibi. So, the very court in this case has ruled who e.g. Parda Asin, the expression Parda Asin connotes complete seclusion. It is not enough to entitle a woman to the special case with which the courts regard the disposition of a Parda Hasan woman, that she lives in some degree of seclusion. Thus, a woman who goes to the court and gives evidence, who fixes rent with tenants and collects rents, who communicates when necessary in matters of business with men other than members of the own family, could not be regarded as pardas in women. Her training, habit of mind, and surrounding circumstances are elements to be considered, And the 17th important leading case under law of contract that we'll discuss, Hummel versus Hunter. So the very case deals with assignment of contracts and undisclosed principles. The very principles of the case are: you have a right to the benefit you contemplate from the character, credit, and substance of the party with whom you contract. And where a man has contracted in writing in terms importing that he is the sole principal, as for example, made a charter party as owner of the ship. Another person cannot be allowed to sue on the contract as an undisclosed principal. So, in the next upcoming video, we'll discuss some other left out leading cases under law of contract.